diversity, laws, policy, practice, and women with intellectual and psychosocial disabilities. I'm so happy to see such a large group of participants to show interest in this topic. I'm sorry for the delay. We started 6 minutes late, just solving some technical glitches. My name is Anna. I'm the program specialist for women's access to justice at the UN Women Regional Office for Asia and the Pacific. UN Women, in partnership with the International Commission of Jurists and the Office of the United Nations High Commissioner for Human Rights, have been implementing a 5-year program generously supported by the government of Sweden to enhance women's access to justice. Our objective is to close the justice gap because we know that meaningful justice is still out of reach for an estimate of 5.1 billion people. There's also an estimate of 350 million women with disabilities in the Asia and Pacific region. And within this group, women with intellectual and psychosocial disability are among the most marginalized and face some of the most complex and entrenched barriers to justice. Denial of the right to legal capacity is arguably one of the most urgent barriers to address. If a woman's legal agency is denied, her status as a person before the law is, of course, also affected. If she's put under guardianship or other substitute decision-making regimes, she might lose capacity to exercise all or most of her rights and have no control over decisions affecting her life. Her will and preferences will just not be listened to and respected. Laws, policy, and practice that restrict or even deny legal capacity can prevent her from participating equally in society and enjoy the rights, her basic human rights. The UN Women Access to Justice team is advocating for a gender-responsive, people-centered approach to justice. That means placing women, justice seeker, at the center of the justice design, moving us towards justice that is more inclusive. This means listening to the women that are affected and create and promote justice solution that works for them. Women with intellectual and psychosocial disability have a crucial role in guiding us through their experience and expertise. Today, I would like to express our gratitude to Transforming Communities for Inclusion, TCI. We appreciate TCI leading the organization of this roundtable, bringing this group of amazing speakers together for this important and somewhat overdue discussion, and of course, for the ongoing partnership with UN Women on the rights of persons with disabilities. I would also like to thank other co-sponsors, especially the International Disability Alliance, as well as all of the speakers here today, to share their experience and expertise to us and to everyone across the globe for joining this discussion. Gatherings like this are so important because we need to listen to each other. We need to identify and understand the challenges together and then collaboratively to share, develop, and implement solutions to close the justice gap for women with disability. I'm very excited about the conversations today, and I'm looking forward to rich discussion. And thanks again to all the speakers and participants. Thank you so much.
Thank you, Doreen, for giving the opening remarks. Hello, everyone. Good morning, good afternoon, and good evening, wherever you're in the world today. Thank you so much for making the time to attend this session. I am Richa, the Research and Advocacy Officer with TCI-Global, and I welcome you to this session on behalf of TCI, the largest global voice of persons with psychosocial disabilities. Before we begin with the speakers, I'll take you through some of the housekeeping guidelines for this session. This webinar is being recorded so that participants who are unable to attend it live will be able to access the recording later. We are providing international sign language interpretation and closed captions for this session. To have access to the closed captions, please click on the CC button at the bottom of your screen. We are also providing Spanish, Mandarin, and Japanese translations for this session. To access the required translation channel, please click on the globe on the bottom of your screen and select your preferred language. For the speakers, we request you to kindly keep your microphone and camera off while you're not speaking. You can turn on your video and microphone when you're invited to speak on the panel. The speakers are also requested to speak at a normal or slow pace, keeping in mind their assigned time, so that the sign language interpreters, captioners, and translators can meet the flow of presentations. We also request our interpreters to please flag us if we need to slow down and in case we are moving too fast. During the event, for the participants, if you have any questions for the panelists, please feel free to type your questions in the question and answer box only, which can be accessed at the bottom of your screen. We also request the panelists that if it is possible for them to respond to the questions directly in the Q&A box, that can be done, or we will take up some of the question and answers, questions towards the end of the session. We will also be activating the chat in a while for our participants, but we request you for the questions, please use the question and answer box. You can use the chat for sharing your thoughts, reflections, introducing yourselves and all. Thank you so much. And with that, I welcome Bhargavi to set the context for the webinar.
Thank you so much, Richa. My name is Bhargavi Davar, and I am Executive Director at Transforming Communities for Inclusion. I identified as a survivor of psychiatry until I started to learn about the Convention on the Rights of Persons with Disabilities. I now identify as a person with a psychosocial disability, having struggled with enduring trauma over many decades after exposure to the mental asylums of post-colonial India. I welcome you all on behalf of Transforming Communities for Inclusion. It's a pleasure to join UN Women, Doreen and Laura Lee, at this webinar. We've had lots of exciting discussions with Laura Lee, which made this event possible. People from dozens and dozens of countries and dozens of countries from around the world have joined us today. Registrations have come from countries which I personally have not even heard about. Thank you all for this interest. We warmly welcome you. We hope that wherever you are, we will be able to reach you with our message across languages, histories of legislations, and cultures. That has been the aspiration of Transforming Communities for Inclusion. The aspiration has been that we can build a collective vision of inclusion for the world despite our differences, our contextual battles in our own countries and regions. That so many people across continents, across oceans, across islands, across mountains, and different terrains have joined us today tells us something. We have missed doing something about some policies for some people in the 15 years of working very hard to realize the vision on the Convention on Rights of Persons with Disabilities. TCI is very grateful to UN Women, the OHCHR, the International Disability Alliance, and the ICJ for sensing this gap and starting a pulse on it. After almost 2 decades of the CRPD, the legal barriers to the inclusion of persons with mental, intellectual, multiple psychosocial disabilities have not been addressed. For us in TCI, we hope that this pulse will turn into a beat and a rhythm over the next 2 years with multiple and repeated studies, actions, and advocacy. And well, I'm a person with a psychosocial disability and I'm allowed my delusions. Finally, there will be a deafening crescendo as the bulwark of incapacity laws around the world will be broken piece by piece allowing persons with social disabilities to live again, rising from their civil death. Why this webinar on legal capacity? Academic resources on this have grown by a small quantum. No further developments in national policies or litigation histories. We used to talk a lot about legal capacity once the CRPD came in, but that debate has died out, and not much outcomes out of those debates. Most of those academic resources have focused on global north countries. Asia Pacific regions have their own dynamic on laws in relationship to disabilities and in relationship to communities. We know very little about that. We have asked very few people. We haven't asked, for example, people inside institutions what they think about legal incapacity and being inside there against their will. It raises some questions, moral questions, of course. There are also legal questions, and there are community questions. Are legal solutions, for example, the only kind of solutions for addressing legal incapacity laws? Can there be also community solutions for establishing supported decision-making? Practices in traditional law or common law, can they be used? For example, registering agreements between an association of persons, or perhaps power of attorney. Asia Pacific poses its own challenges as well as potential solutions for this catastrophe of legal death that many of us face in disability rights discourse. There is an overwhelming response to the call for this webinar. We thank you all for this response. It shows that we are sitting on a burning topic. What to do to advocate with governments to modify, repeal, abolish these laws. This webinar has an Asia Pacific focus. However, it brings expertise from other regions as well. We thank all the speakers who have kindly joined us today. Also, just to share a bit of information, this particular webinar is focused on persons with psychosocial disabilities. In partnership with Inclusion International, we are organizing another one for persons with intellectual, mental, and other disabilities. So yeah, await the news on that one. Well, the next two presentations are basically short videos. Again, setting the context. We are joined now by Rosemary Case. Many of you will know her as the chairperson of the CRPD committee. And following that, we have Sarah Osborne, a young self-advocate from Fiji Islands. So we have these two videos for you to begin with. Over to you, Richa.
For the opportunity to make this address to you today. Women with disabilities are pitted against a justice system that fails to recognise and accommodate our needs. Combined with the denial of legal capacity, women with disabilities have limited opportunities for the realisation of agency, autonomy, and self-determination. The Committee on the Rights of Persons with Disabilities has outlined specific issues and concerns for women and girls with disabilities in its general comment, number 3. Harmful stereotypes, discrimination, the lack of procedural and reasonable accommodation results in our credibility being doubted and our issues dismissed. Our rights to maintain control over our bodies and reproductive health, including on the basis of free and informed consent, to own and inherit property, to control our own financial affairs, are often denied through systems of substitute decision-making. This denial of justice is the outcome of the intersection of patriarchy and ableism. Our ability to seek justice rests with our right to equality before the law and the recognition of our legal capacity. Our ability to hold rights and our ability to exercise those rights. The exercise of legal capacity has most commonly been denied to people with disabilities in legal systems worldwide. But this denial has also been applied to other groups, particularly women and ethnic minorities. The historical denial of the exercise of legal capacity for women, as for people with disabilities, is largely based on the normative standard of what it means to be human. Disability and femaleness are constructed as falling outside this normative standard. The view of the autonomous rational male. Disability is conceptualised as a deficit located in the individual, a deviation from bodily, cognitive and mental norms that requires a range of medical and expert interventions to diagnose, treat and cure. Femaleness is conceptualised as non-rational. These conceptualisations mean that people with disabilities and women are considered as different, as exceptions, as other. We are conceived as vulnerable and in need of protection. For women with disabilities, this has specific, unique and compounding effects. The Convention on the Rights of Persons with Disabilities codifies a human rights model of disability. The Convention recognises disability as a social construct, values impairment as part of human diversity and human dignity, and affirms that impairment can never be the basis for the denial or diminishment of human rights. Importantly, the Convention recognises the diversity of people with disability and outlines an intersectional approach to its implementation. Inequality and discrimination are experienced differently depending on how disability intersects with other personal identities and characteristics, such as gender, age, race, Indigenous and LGBTI status. It means that the issues and concerns for women with disabilities, and importantly, equality before the law and access to justice, need to be specifically recognised, identified and addressed. Until this occurs, the justice system will continue to fail women with disabilities, and the realisation of agency, autonomy and self-determination will be thwarted. Women with disabilities need to be central to the transformation of the justice system. And I'm pleased that today's event provides an important forum for women with disabilities to raise their views, concerns and solutions in relation to access to justice. I wish you well for your discussions and positive outcomes. Thank you.
Thank you so much, Rosemary, for allowing us to share your video here today. Legal capacity issues have been really at the core of your interests well before becoming a member of the committee. In your video, you speak about the need for issues relating to equality before the law and access to justice to be specifically recognized, identified, and addressed. We have been concerned about, despite many years of concluding observations, general comments, and so on and so forth by the committee, this area seems to be quite intractable and no change has happened. Drawing on your expertise in this area, could you share with us perhaps 2 key action points which you believe are needed? Over to you, Rosemary.
And my camera. No. Okay. Please excuse me, I was just a bit slow in getting organised. Thank you. Sorry to look so ghosty. Well, the first key thing is the universal standard of legal capacity needs to be recognised, and it needs to be recognised not just through states ratifying their obligations under CRPD. It needs to be happening in legislation within constitutions around the world. But secondly, we need to be able to recognise that there's vested interests in the lack of the way people are deemed to lack capacity within states. And so we need to recognise that mental health systems and institutional care systems are part of the perpetuation of the injustice that can happen for people with disabilities, and especially women with disabilities. They can be doubly denied justice within those systems. They're not just denied capacity, they are then denied voice in many, many controls in their life, not just about access to justice. So I think it's that interrelationship that not only does capacity have to be recognised, but we need to break down those vested interests around mental health, and for psychosocial disability to be understood in its broadest terms. So we look at the social determinants of individuals' mental health and how that can be supported, but without taking away people's legal capacity, but not only their legal capacity, but also choice and control holistically within their life.
Yeah. Thank you so much, Rosemary. It's really important that we highlight your remark on legal capacity and vested interests. So one of the arguments that we have been making in TCI is how the presence of legal capacity laws fragments interest within families and communities, allowing people to predate on each other because of money matters or legal matters, all of that. So thank you for bringing this up. That's studies for another day. We now invite Sarah Osborne from Fiji. Sarah is leading an organization called the Psychiatric Survivors Association Fiji, young person with psychosocial disabilities, working as many of us in very difficult circumstances. Sarah has joined us today, but she has also shared a video. So Richa, over to you.
Hola, everyone. My name is Sarah Osborne. I am 33 years old. I identify as a woman with psychosocial disability, and I've been working for the Psychiatric Survivors Association for the past 8 years. In Fiji, women and girls with psychosocial disability are mostly not recognized at all levels. This is because of the legal capacity that unsound mind do not have the capacity or the ability to make decisions or the right to choose for themselves. This spills over to all the other aspects of life, mainly, as I mentioned, the rights for them to choose. Make it worse when a woman with psychosocial disability or a girl with psychosocial disability does not have the support from their family. This also affects their daily lives. It worsens their situation as an individual woman with psychosocial disability. Most of these women and girls are experiencing other physical health complications, which is disturbing their daily functions. And I can only imagine these challenges that they go through on a daily basis. It is much more easier to deal with the illness than having to deal with these daily hardships because of the legal capacity. That unsound mind are not capable of making their own decisions, unquote. These are some of the things that have been shared to us by women with psychosocial disability here in Fiji. they are robbed of their happiness. Their lives are their life is taken away. Their dignity is ripped of them. Their identity is messed up due to this legal capacity. Simple decisions like what to wear, what to eat, and who to hang around with is made for them by families and carers. And also their rights to choose the kind of treatment that we feel appropriate for us are made by our families. And when the families are not there, these decisions are made on our behalf by friends, carers, and community, and sometimes community members. Girls have lack of proper access to education at some levels because of his legal capacity and sound mind. And you may wonder how. Do we even make time to think of what these women and girls go through? This improper wording or legal capacity denies women with psychosocial disability the rights to have their own children, get married, and look after their own families. As soon as they're given a medical report stating that they have a mental illness, the hopes of finding a proper job, employment is gone, because no one will employment. No company employs them because of what is in the wording that is in the Constitution, unsound mind. They become rape victims, victims of all forms of abuse, but are not given justice. And this happens in their homes, in towns, in the community setting, as well as the evacuation centers. And they're not because people assume, or because of this legal capacity that they have an unsound mind, people think that they are making it up. They do not know what they're talking about. And due to these the few things that I've mentioned, justice is not given to women and girls with psychosocial disability. Sometimes these same people, they confuse women with psychosocial disability and girls with psychosocial disability. They get confused when they are angry or having, like an episode of being unwell. These women are not part of the women's group activities in our communities, in our in the urban areas. Sorry, they are not part of these movements because of, again, the unsound mind word. Some even lose their jobs. They get divorced, lose their children to their husbands and family, and live a very sad, lonely life, only because of these two words again, the unsound mind. To conclude this, these two words have caused us pain, brought us shame, stole the little dignity that we have. It has taken away our children, and some of us have lost friends and families because of the words that we are talking about, this legal capacity. But today I stand with my sisters and daughters who have a psychosocial disability, that even with this disability, we can still be us. It is you who need to make changes to the legislations, to the policies, to the laws, changes to have this, make changes to these existing laws, the existing laws that we have right now, that does us no good, it does nothing but degrade us and makes families struggle even harder. Society and the government will have more on their plates as it already is. And I can be somebody who can proudly say we can also contribute, to the growth of the society, to the growth of the country, if we are provided with the right support, and also if these positive changes can be made and is ensured that it is aligned or compliant to the CRPD. We can make effective and productive contributions to the society at large. I'll just share my experience. When I had my last baby, I was unwell. And because my family thought that I have an unsound mind, they made the decision on my behalf and gave my son away. So my son is being raised by another family now. But I am capable of looking after my son. I am working, I'm independent. I have 3 other sons that I'm looking after. And I don't find any problem with that. We are happy, we are normal, living normally. And because at the same time, in that same week when my son was given away, I had my tubes tied because the doctors thought it was something good for me. They made decisions for me rather than, asking me or allowing me to choose for myself. And because I was not well, they didn't even give me time, for me to think, okay, do I want to have another child or not? But because of this legal capacity, today sometimes I sit and I cry because I still want to have another baby. I have found a real man who loves me, who accepts me for who I am, and is willing to, to make me happy and my children. But then I can't give him this small thing for me to give him a baby because of his legal capacity. So with those words, thank you.
Thanks a lot, Sarah, for that very powerful sharing of your experiences. Unsound and mind, two innocuous words. When put together, it has explosive, destructive effects on lives of persons with mental, intellectual, and psychosocial disabilities. Many stories, many untold stories like the one that Sarah has trustingly shared with all of us. It is TCI and movements like ours, which is 8 decades old, which have worked very hard to remove the shackles, legal shackles of unsound mind laws worldwide. We've had to use the best of reason, the best of experiences, the best of thought processes, the best of our sound minds to put this out. But still those laws which exist, they cancel out all the reason that we bring to the table on the need for some human beings to be recognized as persons. Eleanor Flynn is going to share next about her legal survey that she is focusing on the Asia-Pacific region on legal incapacity laws. Many of you will know her as Professor in Law and Director of the Centre for Disability Law and Policy at the National University of Ireland, Galway. She's written extensively ever since the advent of CRPD, as far as I know, perhaps even before that, on legal capacity laws. She has special interest in gender and reproductive justice. So thank you for joining us today, Eleanor. I have a question for you.
Sure.
Yeah, thanks. So, yes, so we're terribly interested in hearing about your present work, of course, which you're doing in collaboration with UN Women on surveying legal needs in the Asia-Pacific regions. We eagerly anticipate the results, which I know is forthcoming. You may not have everything to share today. But we are curious, was there any specific finding relating to the regional context and to the global South context when compared to the other regions where you have worked in extensively? So do you have any quick recommendations already how the Asia-Pacific region should proceed forward? Over to you, Eleanor.
I'm happy to talk about that. And thank you, Bhargavi, for the invitation to be here today, and to all of my colleagues from UN Women, and most importantly, from the partner organizations in Fiji, Nepal, Indonesia, and Philippines that we've been working on with this survey, and many of whom are here. And many of whom may have more direct answers than me in terms of what exactly is needed in each of your contexts, which have some similarities, but are also very distinct. I think if I would say there is one quite striking finding to answer your question, Bhargavi, in this context, comparative to some of the global North countries that I've also been working in when it comes to legal capacity, is the extent to which people's legal capacity or ability to exercise rights is restricted informally. So sometimes it is also formally restricted through the legal system, but that seems to be a lot less common in this context. And rather it is communities, families, neighbors, perhaps even people with seniority in the community, but who have no formal legal authority, who prevent women with disabilities, especially women with intellectual and psychosocial disabilities, from exercising their legal capacity, from making decisions about getting married, getting divorced, having parental rights in respect of their children, from inheriting property. And some of these are formal legal decisions, but many times participants in the survey that we carried out said, my family don't allow me, or I tried to do this, but I'm told no. And it's not, they're not formally under a type of guardianship or substitute decision making that's recognized through the courts or by the state, but nevertheless, they are not really seen as full persons with full legal personhood capable of exercising all of their legal rights in their communities. And that is the real barrier. And unless people are aware that they can challenge that they can push back, unless they have the support to push back from others, from peers, from people with authority in their communities as well, from their families, then it's going to be very, very difficult for people to actually have their rights recognized in practice in their daily lives. So I think that's an area where we need to look at. The formal law reforms are also important, but you've mentioned, Bhargavi, that even in countries where we have seen some formal law reforms, we're still not seeing enough progress in terms of the daily lives and the real lived experience of disabled people. So we need a culture shift with key actors in communities, with key actors in the health system, in the education system, in the employment system, to really understand that there is a new way of thinking, and they cannot use their prejudice in the way that they have before to deny people the opportunity to make decisions. So I'll use my remaining time to discuss a little bit the survey that we have been working on that was commissioned by UN Women, which is a legal needs survey of women with intellectual and psychosocial disabilities in 4 key countries, like I've mentioned before. So that's Fiji, Philippines, Nepal, and Indonesia. And so in developing this study, we used an existing legal needs survey methodology that has been developed by the OECD, which is intended to understand the legal needs of marginalized populations in general and be able to measure, for example, how people living in poverty might have their legal needs met, how people in different marginalized communities. So it was not developed specifically with disability in mind. So we had to do some adaptations to the survey in order to make it accessible and in order to make it cover issues like legal capacity that have a specific meaning in the disability context. So we were very pleased that we exceeded our total goal for the survey responses, and that's thanks to the hard work and efforts of our partners on the ground in these countries. So we were aiming for 200 respondents, and we have 232, 34 from Fiji, 95 from Indonesia, 57 from Nepal, and 46 from the Philippines. And we were also anxious to ensure that we included perspectives both from women with psychosocial disabilities and from women with intellectual disabilities in the survey. And the total breakdown of respondents, we had far more respondents with psychosocial disability. 72% of our respondents had psychosocial disabilities and 26% had intellectual disabilities. Now, some respondents had both. Some respondents, as well as these disabilities, also had other disabilities. So the true picture is more complex than this, but I think it just gives you an idea of our respondents across the different partner countries that we were working in. So what were the key takeaways from this survey? We asked, according to the OECD methodology, we asked questions on issues that they had identified, including consumer rights, land, property, inheritance. We asked questions about housing and employment, about family, violence, relationships, parenting, about work, government services and access to money, about health, education, and then we gave an option for people to tell us anything else that they experienced, I suppose, a challenge with when they wanted to exercise their rights in some area. and were not permitted to, or were denied their rights in some respect. So there wasn't one specific question on legal capacity in the survey. Rather, we had different ways in which people could identify the barriers that they faced on each of these substantive topics. And while oftentimes people did not take yes to the question about whether a denial of legal capacity happened to them for each of these topic areas and issues, we could tell by the answers that they gave later on in the survey that actually what is happening is a denial of legal capacity, sometimes formally and sometimes more often informally. And I think that's very interesting. So even though we were surveying legal needs, many respondents told us that it's difficult for them to understand what a legal need is, especially when so many people are focused on basic survival. So thinking about the things that happen to them, many respondents described something which we would see as a denial of rights under the UN Convention as simply being bad luck, or just an unfortunate thing that happened that they have no control over. There's nothing they can do about it. Because again, with the survey, we were interested in what steps the person took to resolve the problem and whether those steps were successful. And the majority of people who responded to the survey told us that even when they did take steps to try to resolve these problems, they were not successful. So we had very few success stories, if you like, of getting justice for any of these issues that people had faced. Some of the issues relating to legal capacity from our perspective then that the respondents did share relate to things like the sale of property or inheritance of property, particularly, for example, where women with intellectual and psychosocial disabilities were excluded from inheritance compared to their other family members who benefited from inheritance. So this is obviously a key issue. Respondents to the survey talked about both being forced into marriage, which was not their decision, which was the decision of their family. And again, we also see very much the intersection of the patriarchy with ableism here, where husbands and fathers were the decision makers for women with disabilities. So it has that kind of specific experience that women with disabilities faced, which is similar in some ways to other women, but also has a distinct and unique experience of ableism there. People were also had experienced difficulties in getting divorce recognized or getting official marriage documents. And again, many of the times they tried to access these documents, they were told they were not entitled to them because of their disability, or that somebody else would need to access them on their behalf. And then outside of formal marriage, people also experience difficulties in just having romantic and sexual relationships. Their families did not permit them to have this, for example. And again, that was often not where people were formally denied legal capacity, but informally, the families were not permitting them to exercise those rights. Another respondent talked about wanting to get married, but the wedding plans always being postponed by her family. So again, a more informal example of denial of legal capacity. We had plenty of examples in the survey of parents whose rights were removed, their parental rights were removed, and again, on the basis of their disability, which relates to their legal capacity as it connects to their parental rights. And then we had examples of, people trying to access formal documentation, government documents not being recognized or allowed to have those documents, being questioned as to the nature and extent of their disability when they asked for support. And again, even where people did seek support in their decision-making, whether from families, communities, or from the state, being denied that access to support, not being given good support, or basically being given substitute decision-making when they had asked for support. We also saw examples of deprivation of liberty connected to denial of legal capacity, again, in the formal context through examples like shackling and institutionalization, including in psychiatric facilities, but also informally by family members being confined to the home, not being allowed to go to work or go to school or to continue their education. We have examples of people being not a lot of the survey responses talked about not being allowed to make decisions or not being listened to when they did express their views on an issue or try to make a decision. So that informal denial of legal capacity is a really prevalent finding. So from our perspective in terms of recommendations, of course, we need to reform the laws that continue to allow for substitute decision making. And in keeping with General Comment 1, we need to abolish all mechanisms of substituted decision making that are currently in the domestic laws of these and other countries. But law reform alone will not be sufficient. So we need to ensure that there is training for law enforcement and justice professionals. We need to ensure adequate human rights education for the rights holders themselves, for people with disabilities themselves. We need to ensure that people know that what is happening to them is not just bad luck or an unfortunate coincidence, that it is in fact a denial of rights and that there are steps that they can take to remedy that. So we need to raise awareness at that level, but also ensure that we make structural changes in the legal and other justice related systems to ensure that when people do raise an issue of violation of rights, that they actually have a mechanism for redress. So at this point, I will pause. I think my time may be up. I haven't been keeping a close eye to see how much time I have left, but I'm happy to take more questions when we get to the question portion of the webinar as well.
Thanks a lot, Eleanor. Well, as facilitator, it's really a challenge for me to, to see how far we can go. It's been amazing, the list of speakers so far and people who are coming in after this. So just to throw in this caution that perhaps we will take some extra minutes before we come to close the webinar. And I think that that's where we are headed as of now. It's so good to hear that not all solutions are legal solutions, and there are many informal community processes going on within families, within neighborhoods, within social units that have to do with attitudes, with the use of the laws which are present, but not actually the going to court and so on, but how they apply and in community settings. It's a pleasure to bring on Matrika Devkota, a person with psychosocial disability, who founded an organization called Koshish, which means making an effort in English. And he's been certainly making efforts since very long after the advent of the convention, highlighting the violations, particularly relating to legal capacity that happens in Nepal. Interestingly, he has also done a lot of work at the community level to break the chains of stigma, and also received awards in that particular category. So over to you, Matrika. So my question for you is you have been extensively engaged with national governments, ministries, and judiciary in your efforts to restore rights of women with psychosocial disabilities to their personhood and to enhance their political participation. Have there been any high points of that? Has there been any legal efforts, studies, cases, or remedies that you actually achieved with this effort? Are these remedies contextual to Nepal, to its people, communities, and cultures? And what needs to happen at the community level, whether there can be programs built around awareness on supported decision-making and human rights, and will that help dissolving the legal capacity barriers? Over to you, Matrika.
Hello, greeting from Nepal, and my name is Matrika Devkota. I'm a person with psychosocial disability. Thank you, Pragavi, for introducing me. So, likewise in Fiji, and all the rights are taken away by law. And for example, most of the laws and those has provision like who would be unqualified and then person with unsound mind and dot. And also like even electoral act, like person with psychosocial disabilities and not allowed to vote by law, and also be the candidate, and likewise person with psychosocial disabilities are not allowed to start organization. And these are the laws. And also what I realize is, so these laws has come from hundred years ago. So this kind of systematic inherited. So even though we have a progressive constitution, and so, but the thing is, latest constitution. But the thing is, in fundamental act, and this has been copy paste from the old and like many years ago. And so this is one part is the legal discrimination by law, and other thing are in other side, the stigma, prejudice, and misconception, and also in one way the dominant of guardianship and the legal system, and that mention like the guardian substitute, and also, and most of the legal system having substitute decision making. And in another side, like I was talking, stigma, and in law, and also the people in the who are in the power, bureaucracies or political, like a parliament and the commissions, these are also been copied and pasted. And also the mentality of people in the grassroots are like, these people cannot decide, and these people, they don't know what is good or bad. So these things has been continuously coming. And what our side is, we are sensitizing it in all the level, from bottom up, and sensitizing to the grassroots. And also for last many years that we are also sensitizing in the parliament. So like Nepal has ratified the Convention on the Right of Person with Disabilities and its optional protocol, and the legal harmonization things, and these things. And also we are working in all the layers, including judiciary. And unluckily, and still we are waiting to get the result, but still these laws are not reformed. But one of the side is that the awareness in the community and duty bearer are quite increasing. Like recently we had also a program with a key person of the parliament, like, and also one way, like, and they really want to abolish that, really want to harmonize that. What kind of sensitization has been increased and knowledge has been increased. There has been some of the commitment, and also in the communities, like there has been more sensitized about the right-based framework, about the CRPDs, but it's still long way to go. Even we have filed in the Supreme Court for dismissal of these provisions. So it has been already 3 years and delaying in the Supreme Court as a public interest litigation cases because of COVID and a lot of other political cases they prioritize, but and the dismissal of legal discrimination provision and also for the voting right. So we are still waiting for that, and also we realize that still a long way to go. But one step at once, our level of awareness and sensitization has been quite increased, and duty bearers they have more verbal commitment, we'll be doing follow-up that. And also this webinar focusing for the women and girls, person with psychosocial intellectual disabilities. And this is the one of the most marginalized issues also in the disabilities and also for the intellectual and psychosocial disability. And for example, abortion or forced sterilization for the women with intellectual psychosocial disability. And even many of the women of intellectual psychosocial disabilities are physically being abused, and also getting problem in the legal system or police that if the girls with intellectual psychosocial disabilities and police not taking the report and they don't toss the mentality, and also in the judiciary system and no supported decision making. So, and especially like the people with intellectual psychosocial disability, people who are high need, no support system and the substitute, and it's quite a long way to go. And one of the areas like Bhargavi, like the awareness has been built among duty bearers, including parliamentarian. And also we have a good opportunity to start also working with a different layer. So judiciaries and parliament and bureaucracies, and as well as to the constitution bodies. And so we're trying to work in different ways. And also we're trying to raise this issue in craft disabilities, and it's not the issue of the only intellectual psychosocial disability. It's for sensory disabilities, and other people also need a support system and like that. And also we're so glad to partner with the university in Ireland, and we are hoping that those recommendations will be very useful. And finally, still there has been some type of sensitization, but long way to go for making the right trail. Thank you for this opportunity.
Thanks a lot, Matrika. I think you brought out several important points which are need to be highlighted. One of them is, of course, that this is not just about mental, intellectual, psychosocial disabilities. A wide range of people get caught in the legal incapacity net. And the second is that having support systems and support services in the community might actually dilute and diminish the need for formal legal incapacity structures to kick in. So I think these are really important points. Really look forward to the solutions that will come forth from the legal survey, both in terms of legal solutions as well as community-based solutions, which, as you know, many of us are involved in creating community-based solutions for support and decision-making. Next, it's my pleasure to invite long-term friend and powerful leader from Indonesia, Yanirusa Damayanti, who's worked for many years on human rights violations of persons, particularly women and girls with psychosocial disabilities, brought on by institutionalization and other forms of legal shackling, including legal incapacity. So she for health. And so, Yani, over to you. You have been extensively engaging national governments and various departments to restore the rights of women with psychosocial disabilities to their personhood and political participation. Can you share some of the high points of this advocacy and some of the challenges? We know that you've got also a case going in the Constitutional Court. If at all possible, then would you like to also share something about that? Over to you, Yani Rose.
Thank you, Bhargavi. Yeah, well, we work with the issue of legal capacity for persons with psychosocial disabilities, especially women with psychosocial disabilities, for many years right now. The first one that we conducted is to challenge the law on a regional election, which prohibited person with unsound mind to be registered as voters. We submit a judicial review to the Constitutional Court, and we won the case with help from you and from other friends from international community as well. The thing is that well, yeah, that's the first one. The second one that we also won the case, I think, is the first law ever in Indonesia that clearly stated that all persons with disabilities, including a person with psychosocial disabilities, has the same legal status as a person without disabilities. That's the new law that just passed by the parliament, which is the Anti-Sexual Violence Act. We contributed greatly in the process of making this law, the Anti-Sexual Violence Act, to put the disability interest and women, especially victims with disabilities interest, into that law. And we managed to put one very important case in which it is declared as the first time in Indonesia in a law that say that all persons with disabilities has the same legal value with those without disabilities. Right now, we are conducting another judicial review to the Constitutional Court to tackle the biggest one, which is the guardianship law. In Indonesia, it is in the Article 433 in our civil code. Yeah, well, in Indonesia, like in many other places in Asia, there are many more informal guardianship compared to formal guardianship, in which that in many cases, people just assume that person with psychosocial disabilities are under guardianship without needed any proof from the court that they are indeed under guardianship. But the thing is that without challenging the legal system, we cannot really change the culture in Indonesia. So that's why we always think that changing the law and creating a supportive environment and communities have to be done hand by hand together. We call it the twin track approach. Change the law and building the support within the community that should be conducted hand in hand. We have many laws in Indonesia that is, how do you call it? Just copying the civil code, just assume that person with psychosocial disabilities are under guardianship and do not have legal capacity. For example, one of the biggest obstacle is the regulation in Indonesia that stated that every job applicants must submit a letter from psychiatrists that say that they are psychologically fit to apply for job. So that it must be done by going through a serial of psychological and psychiatric tests and interview, and then you got a letter stating that you are psychologically fit to apply for a job. Without that, you cannot apply for the job. So that's also one of the regulation that just simply, how do you call it, copy the civil code that's saying that person with psychosocial disability do not have a legal capacity. That's why I said that it is very hard to change the culture within the society, but also other legal system in Indonesia that come, including until now recently, that just adopt the civil code as their source, as their legal source. That's why we conducted this judicial review. Another one within the society, including when people, when the family especially put people or the family members in the mental institution, they are automatically regarded as their guardian without any proof from the court. So this informal guardianship is everywhere in Indonesia. But like what I said, it is hard to change this culture if the legal system says still, adhere to this notion of that persons with psychosocial disabilities do not have any legal capacity. So we now we are in the process, and this process is to challenge the guardianship law, and this process is very interesting because we with this process we also engage actors without outside of the psychosocial disabilities communities. For example, like we got many amicus curiae, amicus curiae, which is letters from friends to the court, that submitted by different disability organizations, including Indonesian Blind Union, Indonesian Women Association of Disabilities, and the Indonesian Physical Disabilities, and other countries, other organizations within the disability communities. But we also receive many support as well from people from outside of the disability movement. One of that is that the National Human Rights Commission in Indonesia agreed to be our partner in submitting this to the judicial review. They act as our related parties that also seen by the court as one of those who submit this appeal. So we kind of like mainstreaming the issue of legal capacity with this judicial review amongst cross disabilities organization and into the mainstream human rights organization, which is we are very happy about. We still working on, the judicial review is still in the process. We still have several court sessions to go, but we have, for example, like Professor Gerard Quinn, the Special Rapporteur for Disabilities, as one of our experts, and Stephen Allen from Validity Foundation, also one of our experts. So we still some court sessions to go, but we are very happy that within this process we managed to mainstreaming the issue of legal capacity of person with psychosocial disabilities, including women with this psychosocial disabilities, amongst not only the cross disability movement, but also amongst the human rights group in Indonesia, including legal aids, including National Commission on Human Rights. So yeah, that's the experience in Indonesia. Back to you, Bargavi.
Thanks a lot, Yenny, for that intervention. And the caution is very well taken, and I hope that we will have more occasion to discuss this in the context of the legal survey work that Eleanor is doing, the broader interest that UN Women and other partners have on access to justice. I'm really glad that this discussion is coming to the Asia Pacific region. Now I request Sharka Daskova, who's a litigation director at Validity Foundation. She makes sure that Validity's legal strategies advance the rights of people with intellectual and psychosocial disabilities in Europe. Very welcome, Sharka. Question for you is that you've been involved in extensive litigation on legal capacity issues in Europe. Are the concerns discussed here in the Asia Pacific regions resonating with those experiences? We find that after many years of the CRPD, the legal capacity rights for women with psychosocial disabilities hasn't changed a lot. What could be the reasons for that? Is it something about legal strategy, legal traditions, legal trainings, or how legal solutions are cultured within those traditions, stopping the way forward to full CRPD compliance? Are there any lessons from the challenges encountered in the European context that you could share that could help us here in this region? Over to you, Sharka.
Thank you, Bhargavi. Thank you very much for the pertinent questions. I will try to answer at least some of them, although the time is short. I'll try to summarize some of our experience here in Europe, mainly because that's where Validity mostly works on guardianship litigation. And thank you for the invitation for this webinar. I really cherish the invitation to speak here alongside colleagues whose work I really necessary, of course, to challenge the oppressive systems and obtain redress, but they may not necessarily bring the positive solutions as to achieving real change and supports in the community. So as a human rights organization, Validity has long been supporting women in their fight to regain the recognition of their equal legal capacity. And we're close witnesses of the horrible human rights violations that they experience, some of which Sarah Osborne actually described earlier in her intervention, ranging from denial of reproductive rights, removal of children, or the refusal of the right to marry or have family altogether, the removal of property and documents, basically leading to enslavement. Our key approach at Validity is to deploy innovative legal strategies to force the states to remove the systems of deprivation of legal capacity and guardianship, whether formal or non-formal, and introduce legally regulated systems of supported decision-making. Now, but I think that it's quite increasingly obvious that this legal fight and legal regulation alone cannot bring the change that we're seeking. Law is a conservative system. That's what we see all the time. There's a long-lasting inertia in legal structures, and European legal systems that have traditionally had paternalistic and oppressive approaches to people with disabilities and their legal capacity, they really struggle with embracing a different approach that is required by the paradigm of support, right? We're stuck in the past, so to speak, and we need a change of culture, as I think Eleanor mentioned. So even though we have seen the adoption of different supported decision-making schemes and laws across jurisdictions, really, many countries hardly see them employed in practice, or if they're employed in practice, actually practically helping people with psychosocial disabilities. There are many reasons for that. I will mention two that the time will allow me to talk about, and two that I think that are important. And one is what I would call the failed paradigm shift. The thing is that the supported decision-making schemes across Europe are still introduced as more or less formal legal arrangements alongside guardianship. They're still legally regulated as a part of this oppressive package, I would say, dealing with legal capacity. And this means not only that legal reforms have only gone halfway in implementing Article 12 of the UN CRPD. In effect, it often means that the supposed paradigm shift that should have happened in understanding legal capacity is not really happening. Supports are often viewed as a softer form of guardianship, an obscure concept, even as we were told by a judge. And so, unaware of this paradigm shift that is supposed to be underway, or maybe simply not understanding or accepting it, the conservative legal professionals deciding about legal capacity in Europe will almost inevitably opt for the old and known guardianship rather than the new and unknown concept of support that may seem quite similar to them. And even when support decision-making is considered, the old paternalistic approach still visibly transpires into the core decision-making about those supports. So only those who are seen as having the capacity, quote unquote, to mitigate the potential risks of decision-making, they are seen as qualifying for supports. And for others, supported decision-making is not even considered to be an option. And so yet again, even within this regime of supported decision-making in law, assessment is used to divide the capable from the incapable, and is used as a pretext for denying rights. And so at best, as we see in several jurisdictions, introducing supported decision-making in law really basically just slightly moved the threshold for deprivation of legal capacity, but there is not a lot of practical change. I think another reason for why legal reforms are failing is what you might call legalism and missing structures. Yes. So operating within the traditional legal approach, regulations, as opposed to practices, are often seen as decisive. So countries such as Czechia and Bulgaria, countries where we work a lot, the systems of decision-making basically comprises of several legal paragraphs which have little connection to what happens in practice. So instead of focusing on what happens in practice and how that works, they're focusing on how to draft it in regulation, and there's little connection between the two. And the countries are really sorely missing the essential structures which would make supported decision-making a reality. Accessible information, the know-how of support, or supportive social networks and services. So I think this is really the harm done by the guardianship systems in Europe that runs deep. Legal professionals typically take it as a given that supported decision-making schemes need to fulfill essentially the same function that they expect from a guardianship. That means fully protect the person from all potential harms that they may incur by decision-making. And we have learned to rely on these highly regulated systems, on our societies that regulate everything, on the state support and instruction, on formalizing those relationships. And we know that this actually misses the point, because the ability to make decisions is learned. It's learned by turning to people that we trust, by asking for help, even by making mistakes. All of us do it on a daily basis and have natural networks for that. Just the guardianship laws here in Europe, at least, really kind of taught many legal professionals to think about the decision-making of people with disabilities differently. And so I think I would caution that the rigidity of law can lead to new legal concepts, or to new concepts, to new paradigms being filled with the old approaches and ideas which frustrate any real change. So in fact, the introduction of some supported decision-making schemes in Europe has certainly meant relatively little for many women with psychosocial disabilities. And so the legal formalization of supported decision-making may not be a key solution, just as legal arguments may not be key for convincing judges and others to use them in their decision-making that legally formalized supports through judicial proceedings. So I think we mainly need to impart the message that the paradigm of support is not only practicable, but that it's also demonstrably less harmful to women with psychosocial disabilities, even if it doesn't prevent all potential risks they may experience. We all experience them. We need to talk between jurisdictions and learn from another. And I think that the European jurisdictions should probably do more listening than talking in these conversations. Thank you.
Well, thanks a lot, Sharka. That was a very sobering presentation. It was so great to hear what happens when the law goes too far in controlling lives of persons with psychosocial disabilities, and of course, disabilities in general. So yeah, I mean, it becomes all the more challenging for us to think of solutions for the Asia-Pacific region. What we experience is the burden of history coming from somewhere else. I really hope that there will be some spaces where some new ways of looking at support systems and support services is possible in the Asia-Pacific region. Yeah, coming to closing now, I am delighted to invite Stephen Allen to make the closing remarks. He describes himself as a lifelong social justice activist, and I wish for you a long, long life and multiple long lives, Stephen, along with multiple long lives for all of us, because this is something that has been just lingering on for centuries, and it requires multiple lifetimes to address it. Presently, Stephen Allen is Executive Director at the Validity Foundation, which is really leading a lot of discussions around legal capacity and human rights of persons with psychosocial disabilities. We had the honor of working with Validity also in the context of the deinstitutionalization guidelines. So really, Stephen, we want to move forward on legal capacity barriers and illegal incapacity barriers and see how those can be broken. And hopefully it shouldn't take a lifetime for this. This topic has not moved, as you know, and many more diverse groups and populations are getting snared in this net. Do we even have a full handle on the problems? Whose problems? What problems? Can you share your thoughts on the present predicament, what we've heard today, the way forward, as a way of closing the session today? Over to you, Stephen. Thank you for joining us.
Thank you so much, Bhargavi, and thank you to your whole team at TCI, as well as colleagues at UN Women, for inviting me to join this incredible panel today. I commend your very explicit intersectional focus in this discussion, seeking to address both the practical but also the symbolic forms of oppression that guardianship systems have on women with psychosocial disabilities here in the or there in the Asia Pacific region, but also globally. Last month, as you know, I was honoured to appear before the Indonesian Constitutional Court alongside you in the groundbreaking judicial review proceedings currently being brought by Yeni Rosa and her team at the Indonesian Mental Health Association against that country's guardianship laws. Interestingly, as has been spoken about a lot today, while guardianship of persons with psychosocial disabilities sits on the statute books in many countries, and this is part of the colonial legacy baked into Indonesia's constitutional and procedural legislation, it is noticeable, I think, that it is rarely used in practice. What then, might you wonder, is the big problem here? Is it a legal problem? Or to put it another way, shouldn't we just ignore the existence of this little utilized mechanism to restrict and deny the legal capacity of people with psychosocial disabilities? Shouldn't we just hope it all goes away? We emphatically cannot. The damaging effects of guardianship systems have been well enunciated by your other speakers today, and they go far beyond the individual guardianship orders made. Most commonly in cases where the women and men involved have property or other interests that others wish to control. Indeed, perhaps the biggest reason we need to continue challenging these abusive and outdated systems is because of their symbolic effect of degrading and devaluing the inherent dignity and autonomy of persons with psychosocial disabilities worldwide. The mere existence of these legal institutions points to a far wider range of legal, policy, and attitudinal barriers that we've heard a lot today about, faced by women every day in achieving inclusion and equality within the political and social economy of our societies. These laws signal that persons with disabilities can still be subjected to the control of others, whether in their best interests or in order to protect that nebulous concept of the public. Such laws serve as the basis for widespread discriminatory practices that degrade the autonomy and dignity of women and persons with disabilities. You've heard about it, from forced medical treatment to the denial of the right to work and to manage one's income and beyond. These laws present an almost insurmountable barrier to accessing justice too, placing the onus on women to prove their sanity before their statements have the weight of evidence, including in cases where they have suffered sexual or gender-based violence. In short, guardianship laws signal a dangerous presumption against the competence and human dignity of both women and persons with psychosocial disabilities, and thereby serve as the basis upon which a whole plethora of restrictions and privations can be and are imposed on them on a daily basis in so many countries. So to the question I have been asked to address, are legal capacity laws unchangeable? While change has been slow since the CRPD entered into force, I believe we are now seeing some positive developments, showing that old guardianship systems can in fact be abolished in national laws, from Latin America to Eastern Europe. And although time is short here to look in detail at the driving factors of each law reform project, I believe there is hope, and there are a few features which I think can give us some cause for positivity. First, it is clear that successful changes can be achieved when persons with disabilities and their advocates work together with other social justice activists and particularly feminist movements. This necessarily places a sharper focus on the intersectional harms of guardianship regimes which disproportionately affect women, including those with psychosocial disabilities, and provides us with a greater range of advocacy platforms whereby we can claim universal legal capacity outside the disability box alone. Such collaborations centre the lived experiences of women with psychosocial disabilities and allow us to show the inherently misogynistic and patriarchal attitudes that need to be overcome for us to achieve more inclusive and just societies. Secondly, I believe that our movements to achieve universal recognition of legal capacity are strengthened when we recognise guardianship laws as part of the colonial legacy of many societies, a legacy that now needs to be decisively dismantled. The truth of the matter, and I say this as a British white man, is that guardianship laws were commonly imposed on countries that were colonised, often copy-pasted into constitutional systems during incomplete processes of decolonisation. Branding people as idiots and imbeciles in constitutional laws is a remnant of 19th and 20th century imperial power, the types of powers that profoundly disrespected the autonomy of peoples, women, and nations, and as such, their removal is a necessary feature of decolonisation itself. Third, development programs over the last 2 or 3 decades have increasingly become more explicitly inclusive of both women and persons with disabilities. From targeted micro-grants programs to national political projects aimed at increasing overall political representation, and captured in the core goal of the Sustainable Development Goals to leave no one behind, there is now increased awareness that economic development is intimately connected to gender and disability justice. We can and should leverage this momentum, forcefully pointing out that women with disabilities must be part of the solution and understood as such in achieving equitable development. Guardianship systems are therefore a barrier to this cause. As I close, I confess I paused substantially before agreeing to speak at this webinar today. This was in acknowledgement of my own identity as a non-disabled British white man. I was convinced to join by the organisers in the spirit of building coalitions and allyship, and because of my own personal and professional commitment to promoting the rights of persons with disabilities. Judges and legislators often have similarly privileged identities to my own, and they can be hard to convince. But I want to close by saying it is a true honour to join with all of you in this very important battle. Indeed, we have a lot to learn, and I think our legal systems do, but together we are certainly stronger. Thank you.
Oh, thanks a lot, Stephen, for the really amazing, powerful closing to the session. Evidently, from all that we have heard today, we have a lot of work ahead, and it's been a really purposeful meeting today. It was really exciting to see the number of people interested in this, and also the thoughtfulness with which each of the speakers brought their experiences and their expertise to reflect on the way forward. We look forward to being with all of you. Thanks to all the speakers, to all the persons who supported the program, the interpreters, the language interpreters, the sign language interpreters, the captioneer. Thank you all so much for being with us at every webinar, supporting us. We thank of course, the TCI support team is amazing, and I thank Wakar and Richa and Fiza for making this really seamless. It's never seamless with technology, but we got a really good deal today. So thank you all so much for being with us. I hope to share a video in the coming days. Thank you so much. Have a good afternoon, morning, evening, night, wherever you are, and hope to see you soon.